Hi, everyone. Welcome to another episode of Divorce-a-Palooza. And what I want to talk about in this episode is child support. So, if you've never been through a divorce, you probably don't know anything about it, how it's calculated, how you get it. And so we just want to give you a brief overview today about what child support is, certain things, anything you might want to know. My guest is Colleen Breems. Colleen is a divorce attorney. She's a partner with Bierman. And hi, Colleen.
Hi, Jackie.
Always nice to see you.
Well, thank you so much for having me. It's always great to see you.
So, Colleen, how long have you been a divorce attorney?
I've been a divorce attorney for just over 10 years now, which is hard to believe. It feels like I started just yesterday. And I think part of that is because there's always so much to learn in family law. It
Mm.
really is called the practice of law for a reason.
But Colleen actually went over to and joined Bierman how long ago? Maybe a year or two?
A year and a half ago at this point.
Mhm. And
Also
Bierman is
feels
one of
like
the best
yesterday.
firms in Chicago. It really is. And we're happy that you took the time to join me for this because don't you feel like when people get divorced, they're like, it's so overwhelming. And then it's like, okay, what is child support? Like, I didn't even really understand it when I got divorced. So, the first question I want to ask you is how does somebody start receiving child support? Like, what do you do?
Sure. Well, I think it's actually first important to define what child support is so our listeners know exactly what it is we're talking about. Child support is a sum of money payable by one co-parent to the other, and the purpose of it is to cover basic necessities for a minor child. So food, clothing, shelter, those basic necessities. And over and above a child support payment, could we be talking about contribution to expenses? So, educational, extracurricular, religious, if any, expenses are just examples. But talking about child support itself, that first part we talked about, in order to start receiving child support, one of two things needs to happen. Either someone needs to file a motion within their divorce case seeking what's called temporary and permanent child support. Temporary meaning payable while the case is pending. So that way, someone doesn't have to wait until their divorce is finalized to start seeing that support come in. And then permanent, meaning child support that's payable once the divorce is finalized. Doesn't mean it's in place forever. It's only meant to be in place for when a child is both under 18 and still in high school. Um, and the other way to have it is in a divorce case, the parties can actually enter into an agreement for child support. And that's much more straightforward, less court time. It involves calculating child support in a way that makes sense to both parents and submitting a proposed agreed order to the court to get the court's blessing on it. Those are generally the two ways where we have child support in place in a divorce case.
Okay, now you said that the temporary is until the divorce is finalized. And is there any statistics on how long an average divorce case is? Because people listening might be thinking, well, we don't have much. It's not going to take that long. But I think most divorce cases I've seen, some are a year, some are a year and a half, 2 years. And so you have to have two different things, temporary and permanent. And my second question is, are they the same or can the amounts change from the temporary to the permanent?
So those are great questions. The first one is there's no hard and fast rule or standard for how long a divorce case is to take. It really is case specific and it really depends on the family. Generally speaking, the less there is to fight about, the more agreements there is between the parties about their financials and their children, the quicker it goes. And the more that there is to fight about, generally, the longer it can take. The shortest divorce case I've done was perfectly uncontested. The parents were in agreement with everything. And the majority of the time was spent just waiting to get on the court's calendar to finalize it. So we were able to finalize that divorce in just under a month. That's my record.
Wow.
And then it could go much longer, as I know that you are aware. So that's the first piece. The second piece, temporary versus permanent child support. One thing to know is it absolutely can change, and here's why. Child support is always modifiable. And what do I mean by that? Child support can be calculated based on both co parents' respective incomes, as well as the number of overnights split between each parent with their child. So, with that, those numbers can change. Parenting time overnights can change during a divorce case or even after, and incomes and employment for the parties can change and fluctuate during the divorce and after. So the figures can be recalculated based on those substantial change in circumstances during the divorce case and also after the divorce case. Just because you have one figure doesn't mean it's going to be that way forever.
Right, because a lot can change in a year, year and a half. Okay, now, Colleen, you said there are basically two ways to receive child support. One, you can go to court and wait for a date and then get the temporary child support, or you can come to an agreement. Do you usually try to just come to the agreement? Like, how do you know which one is better for you?
That's a great question. And I would say with most cases, I like to talk with my clients about the cost benefit of duking it out in court and spending a lot of time in protracted litigation. And sometimes that's the way we need to go. Sometimes we're dealing with someone who's not going to come to the table, be reasonable. Sometimes we've got instances of abuse or other factors we need to consider when we're talking about what type of person we're dealing with on the other side of the table. Um, but in most cases, I do like to try to start out the case on an amicable foot because that saves time, money, and stress for the clients. So I work with the client usually at the outset of a case to come up with a full settlement proposal of what they think is fair in their divorce. And that includes support. And we tender that to the other side for their evaluation. Best case scenario, they sign off on it and return it. We're able to move forward in finalizing the divorce. And the other side, which is also helpful, is they let us know which portions they're not in agreement with and why. So that allows us to narrow the playing field and also allows us to determine next steps in the divorce. Um, I do tend to find that it's better to try to come to an agreement on child support because it is so formulaic. If once we know the number of overnights and the incomes of the parties, it's pretty straightforward, and that's usually what the court will go by, unless there's a substantial circumstance that needs to be considered, that something that's unique about the needs of the children or the case itself.
Okay, now what's so interesting about what you just said, and this is what I want to tell people watching. So, if you have the choice and you're so angry with your ex that you think you're going to go to court and you're going to be able to tell the judge what he did or she did and get your day in court and have it, that's not going to happen. So, what I'm hearing from you, Colleen, is that if you come to an agreement, you can pretty much say, here's the formula, here's most likely what a judge is going to rule on because it's a formula. It's very specific. It's not like other decisions made by a judge where they're more unpredictable. This is very predictable. So, are you saying that people are better off just agreeing and not having a judge determine the child support amount because it's so predictable?
If at all possible. Again, we're not always
Right.
dealing with people who are completely reasonable on the other side. And also, sometimes there are specific situations or factors that the court needs to consider and the court needs to weigh in on. For example, if the number of overnights between the parents is up for debate, or them, the income figures themselves for the parties are up for debate, that's where we may need the court to intervene if we can't reach an agreement. And both routes are totally fine.
And also, don't you feel like tell me if this is the case, at the beginning of the separation, when we're talking temporary child support, that's when I think people are most insecure about the parenting schedule. And so they want all these overnights, and they might realize later that it doesn't make sense because they're more secure later. And they say, okay, the kids still love me, even though I'm only seeing them 3 days out of the week. It's still we have a great relationship and everybody kind of relaxes. Do you find that?
Most often, yes.
Mhm.
And every case is different, but I think when a divorce case is brand new, that there is a lot of insecurity. There are a lot of unknowns. People are afraid of what's going to happen with their kids and what's going to happen with their finances. And they're also going through, most often, the grieving process of grieving the marriage and the life that they expected to have. So there's a
Right.
lot of emotionality there. And so I think that when there is a lot of emotion, you're not always getting the most rational decision. So that's where it's extremely helpful to have the right divorce attorney in your corner who can be that cool, calm, and collected head and guide you through that emotionality to make sure you're making the best decisions for you long term.
I love it. Okay, couple more questions. You talked about how child support is always modifiable. So let's say something changed and you feel like you need more income. What do you do?
Yeah. So if there's been a substantial change in circumstance, and by that I usually mean a substantial change in employment or income, or a substantial change in the number of overnights that the parents are having with their children. Again, someone can file a motion to modify child support if there isn't an agreement, or enter into an agreed order about the recalculation of child support based on those factors. And pretty similar to how I described commencing child support, those are the two routes to go. No matter what, there should be an order entered that modifies the child support if it is to be modified. I would never recommend just having a verbal agreement between the parents, and then just moving on with your lives because that can come back to bite someone. It's always really important to make sure that significant agreements like that are in writing and part of the court file. But you could do that by agreement, best case scenario, or a motion to modify if no agreement.
And right, because if you can just come up with the agreement, whether that's in mediation or mediation between the attorneys, and you come up with an agreement, then all you guys have to do, meaning you guys, meaning the divorce attorneys, is enter an order into the court, and that doesn't require much time at all.
Mhm. Right there.
Okay, last question. I just was thinking about this. So, child support ends differently in different states. Like in Illinois, it ends when the child has turned 18 or graduated from high school, whichever comes later. Do you have to go in and terminate it, even if, or do you just assume that everything's fine after your child turns 18, after it's done and you just stop paying?
Well, if you have well-written orders, it should provide for termination. And generally speaking, we look at when a child is going to be both 18 and graduated from high school. And we could have language that says that child support is to terminate upon the attainment of those two things, and also presuming that the paying parent is current and not carrying an arrearage of child support. Um,
Oh, right.
and so hopefully it goes forward that way. Otherwise, if someone is seeing that their paycheck is still being garnished, even when child support should have stopped, that's when I suggest that they file that motion to terminate child support if they haven't already.
Well, Colleen, thank you so much for being on Divorceapalooza.
Thank you so much, Jackie. I so appreciate getting to chat with you as always.
As always, Colleen. And tell people who are watching what's the best way to get a hold of you if they want to have a consult with you or have questions.
Of course. So again, my name is attorney Colleen Breems, B as in boy, Reee, M as in Mary, S. And my email address is my first initial and last name, C Breems at biermanlaw.com. Important to remember that Bierman has two E's and two N's. And my phone number is 312-621-9700.
You can also find Colleen in the trusted professionals section of Divorced Girl Smiling at divorcedgirlsmiling.com.